Good day and welcome to everyone. I trust I'm audible enough and you're all able to hear me. I would like to welcome you to our webinar on trademarks and designs. Now, I trust you are all well. I'm happy to see quite a number of names that I'm quite familiar with. I trust that we're going to have a very engaging session. And most importantly, I trust that today we will be able to walk away with the knowledge required in order for us to be able to implement that which we intend on talking about today, which is the registrations of trademarks and designs. Now, welcome once more. But prior to us starting, I would like to go through a couple of ground rules in order to make sure that we are all engaging in the platform as professionals, but most importantly, that we are all able to engage, but in a more systematic and a more controlled manner, that way everybody gets a chance. I would like to start by saying this: if you are not able to hear me and I'm not audible enough, please do send us a message in the chat section or the Q&A section, where we will be able to look at our technical sounds. Where you think that we are freezing, please do check your internet connection first. The problem might be on your side, but if it is on our side, we should definitely know on the number of participants who let us know that they are not able to hear us. Welcome to the session once more. As said earlier on, the name is Khunzi Mope, and I trust that you are all well. My role, I will be later on introducing when we start with the session itself, just to go through the webinar agenda and the couple of ground rules. Now, in terms of housekeeping, ladies and gentlemen, I would kindly request that you all remain muted when you are not engaging with us. So which means that when you are not speaking, kindly do mute yourself, and you can also switch off your video or deactivate it, because of the video increases the bandwidth required for you to be able to hear us. Now, when you reduce it, then the sound becomes a little bit more clearer. Over and above, when you have any questions during the sessions, please feel free to put the questions on the Q&A section at the bottom of your screen. On the tab, there's a Q&A. Please feel free to make use of that. However, if there's anything that you might be requiring clarity on while I'm still presenting, please feel free to raise your hand. We do have technical support online. We should be able to take note of that. Most importantly, when you do ask your question, if it is possible, kindly do raise your hand first. When we pick you to be able to speak, we will ask you to unmute yourself. We will also ask you to switch on your video so that we are able to take your question as you explain it. When you are done and we are delivering the answer to the question, I would kindly request that you mute yourself once more. And once muted, you also then can deactivate the video in order to be able to hear us clearly. So we don't have a lot of rules. They are very simple, and I believe that as professionals, we should be able to keep to them. But over and above, for the agenda itself, we're going to be looking at the part where we speak mainly to introducing the subject of today. And we're also going to touch on why you should register for trademarks and designs. And then we're going to have a Q&A session, and then we will be closing the session. This particular session has been scheduled for 2 hours. I would kindly request that you take note of the fact that we do not need to be here for the entire 2 hours. I would like for us to be able to complete it within some time at 3:30, so that I'm able to allow you to make it for the road wherever you need to be traveling, if you need to be traveling before peak hour traffic takes off. Now, thank you very much. Now, as previously indicated to you, when you do have any questions, please do make use of the question and answer. Do raise your hand when you want us to take note of you, and also make use of the chat function on the slides or on the platform itself. Now, we want to talk briefly about why should one register for trademarks and designs. And in doing so, I would like to be able to inform you of the fact that this trademarks and design webinar is held in conjunction with SNZ attorneys. So the SASDC presents the webinar on behalf of SNZ, who we are also certified and licensed to do trademarks and designs on their behalf and in partnership with them. SNZ attorneys have been the leading patents and registrations of trademarks and designs in terms of filing in South Africa for quite some time. And we have been able to utilize the system with them. All of the systems that we utilize and the process itself follows an online system that requires, or rather enables us to be able to deliver this particular services a lot more quicker and a lot more efficiently. But most importantly, we are able to deliver it a little bit more in terms of being cost effective as far as what we do as an organization. But prior to also getting into then the subject of the day itself, I would also like to bring you into then the understanding of the SASDC and who we are. The SASDC is then an acronym representing the South African Supplier Diversity Council. As the name says, we are a non-profit organization. We are a council that is responsible for promoting, improving, establishing, and making sure that the communications and the enforcement of supplier diversity is put in place. So basically what we do is that we certify suppliers, we connect them, and we celebrate them together with our corporate members, with the key intent being to grow the organizations of SMMEs and to also be able to see them be able to compete in the global and international markets. Now, the subject that we are speaking to today is trademarks and designs registrations. We are not talking about patents today. So if we have any patents questions, please do feel free to put them in the Q&A. Where we are able to take them, we will be able to take them. Where we are not able to, we would definitely be able to come back to you with your questions through your email that you have put in the registrations. So we thank you very, very much for joining us today, and we hope that you will enjoy this session. We would like for you to be able to start familiarizing yourself, or rather listening with the intent to see where does the subject fit within your organizational context. Now, it is very easy that when we start our organizations, we have these brilliant ideas. And the intent to which what we start them for is that we do understand that there is a gap that needs to be filled. And what our organizations intends on doing is for us to be able to provide services that allows us to do that. And it's always then very imperative that we have the understanding and the knowledge and the insight behind how do we best protect our information. Now, prior to me starting with then the actual presentation itself, which I'm opening, I would like to be able to once more reintroduce myself. The name is Huntse. The surname is Mope. I am the Training and Development Specialist for the South African Supplier Diversity Council. I am a licensed and certified business advisor with Growthwheel. I am a certified trainer and facilitator with the Education and Training Development CETA. I'm also a constituent with the ETDP CETA together with Construction CETA as a trainer, facilitator, and an assessor with them. Over and above, I am a qualified mechanical engineer with an honors acquired from University Technology Petronas in Malaysia in Ipoh Perak. I am an entrepreneur and a business owner, and I have also spent a lot of time in the petroleum, oil and gas space, but I spent most of the last recent years, over half a decade, specializing in supplier and enterprise development. So which means that acting in the role and the function of a business advisor. Through the SASDC, I've had the pleasure and the honor to interact with over more than 500 enterprises in the development conversations. And part and parcel of what I found in my experience and in the work that I do is that there then sits in a lot of knowledge gaps in terms of what we understand as entrepreneurs and how to best protect that which is our intellectual property or even the niche of our organizations. Now, I have said we started these organizations because we had these brilliant, magnificent ideas. It is all good and well that we were able to be considerate, to consider ourselves the right service providers in order to be able to close the gaps. Now, the gap that we identified might be in a product, might be in a service that is needed within our communities or within the country or the global market itself. you understand why that was very imperative for you to start engaging with and even embark on registering your organization and the services that you intend on providing. But what most of us as SMMEs, rather, as entrepreneurs, when we start with our organizations, what we tend to miss out on is then the part where in life, and I find it to be a very, very interesting perspective when one really looks at it, is that in life, just like anywhere else, or just like with everything else, it is easy for people to want to steal your idea and take it for themselves. It is even a lot more easier when people want to be able to make money out of the very same concept or the product or the services that you sell to your clients because of they seem that it's profitable. Now, how do one best protect that particular niche that they have within their organization? And this particular session of the webinar today, it's mainly intended to bring the awareness required in terms of what are the processes, what is the information, and what does the law says in terms of protecting your intellectual property. Now, truth of the matter is there's a lot of ways of looking at how we run our organizations, but being able to run the organization from a perspective of understanding that the law protects you, it's one of the best ways of understanding compliance, but most importantly, of understanding how to do business in the corporate space. Now, one might think that by merely registering their company name, by merely registering their slogan, designing their logos, or even putting together a proper product is sufficient in order to be able to improve their clientele relationships. And when you do that, you will be completely correct. But what you need to understand is that your competitors are probably looking at the same clientele, are continuously performing their own research, and are continuously trying to find how they can best improve on their services and their product offerings and ensure that they are able to compete with you. Now, what happens at times is that then most of them, these particular organizations, would then go about and might even copy the very same product, the very same slogan, the very same catchphrase, or even the very same design that you have decided to put in place in order to be able to address the issue. Now, truth of the matter is you should expect that it will be stolen as an idea, design, or a slogan simply because of it hits the mark. It is what the client wants. And if it is what the client wants, then that is what every organization wants to be able to provide. What cannot be accepted, it is for this particular information to be stolen, and then you are left without any protection or any way to best defend your particular product or service. So let's speak about how do we then best protect them. And in the webinar, when we sent out the invitation, I tried to best suit it so that it is understandable to why is it that it is necessary that we have this particular session. My take and my understanding is that in businesses in life, there are many who will easily want to hijack, be it that is your name, be it that is your logo, be it that is whatever the design that you might put together in place in order to be able to best service your clients. And for us to be able to then ensure that this particular information is well protected within our organizational context, it becomes then very imperative that we fully understand to what are we speaking to, and that then we are able to quench all this confusion from our competitors when our clients need to buy our products and they do not know which product really belongs to us. So let's talk briefly about what we would expect in this particular presentation that I've prepared for today. What we look to discuss is the purpose of designs and trademarks registrations. We also would like to speak about the requirements and the specifications that then accompanies the applications. We would like to talk about then the process of the application itself and the benefits to registering your trademarks and your designs. But we will also cover in detail or in brief what are the costs related to the registration of a trademark or a design. And we will also share some insight as to how can we not be blindsided and identify the risks to our intellectual property before we actually go through the risk itself, or we are even exposed to the hazard. I trust that you are ready, and I trust that we should be able to have an engaging and a fruitful session. I can see that we already have a first question, and the first question is sent by Craig, and Craig was asking whether the session is recorded or not. Craig, the session is recorded and it will be availed on the SASDC SD Academy YouTube channel, where we are able to upload all of our webinars and also ensure that all of our clients have continuous receipt of the information that we share with them. So let's speak about why trademarks and designs registration. So when we speak of trademarks as opposed to copyrights, so we all know that copyrights would first fall under then the common law of protection of intellectual property. But what differs from the trademarks then to be the copyrights is that the trademarks protect a specific function, a specific name, a specific design, a specific title that is then something that the organization utilizes as a niche in order to be able to best market their products. So basically, it is you wanting to best protect the identifier of your organization, the things that your clients best relate to and are best able to identify you with. Those are the things that you want to protect so that your products are not mistaken for the competitor's products, or even the fact that the competitor becomes deterred from stealing your products and utilizing it and selling it as theirs, right? So that is the key reason as to looking at the why of the trademarks and designs. So now we're going to speak about designs. And when we look at then the design registrations, the design registrations covers a wide range of then the designs. But what it really speaks to is that any product really can be slightly changed. I mean, you have to really see it in your household and ask yourself how many coffee mugs you really have, and ask if the coffee mugs are all the same. And you will then start identifying with the fact that although they are all mugs, they are not the same. It might be a difference in the shape, in the holder, in maybe how they open, but the point is they might not be the same. And because of they are not the same, it is always best to then register those particular designs, and especially for one particular reason. If the design itself assists in then the product being able to perform the function that it performs the way it does, then you are ought, or rather advised to do so. But most importantly, it should be something that also brings about a niche to your particular product or to your particular service in that perspective. And with that said, I just want us to be able to first look at different types of designs and be able to understand what the design speaks to and what is it that we're going to be talking to. So when one speaks to designs, we look at patterns, we look at shape, we look at configuration, and we also look at ornamentation. So let's take, for example, pattern. And I would like to use simpler examples that we are able to relate with. I've always found that the subject of patents, designs, and trademarks is always rather a complicated one, and not because of it is a complicated subject, but it is complicated because of the language and the terminology applied. And I would like for us to be able to simplify it with then examples that we are easily able to relate with. So let's speak pattern. One has to start identifying that there are a lot of painters in this world. So we're going to remove ourselves from the world and we're going to bring it to a closer contrast where we're going to look at our country, South Africa. So we have a lot of painters in our country. And just to mention a few, we have Rasta, and we have as a matter of fact, we have a lot of painters. But each painter paints in a specific manner, which might differ from one to the other. One painter that has really stood out is the lady from Swaziland, is it, I believe, who does the paintings on behalf of the Ndebele lady, who does paintings in terms of the various Ndebele patterns. Now, BMW has resourced or outsourced a requirement to have the lady come and do a couple of paintings as custom jobs for them, for BMW. where the lady went to BMW and gave them a number of designs in terms of how to paint the cars, right? That is a pattern. How she draws, or rather how she paints, speaks to a pattern that she uses in the Ndebele patterns, or even the Ndebele colors. That on its own will speak differently from any artwork that is performed by anybody else. So you are able to then look at that particular pattern in terms of how they are structured, how they are brought together, how they are assembled to be able to complete the picture that she wants to be able to complete. Now, that will be something or a pattern that is uniquely identifiable to what she does. The moment you see those colors and you see those patterns anywhere, you are automatically able to relate to them and be able to automatically then familiarize them with her. And that is very important, right? Because of then, that is how she stands out from the rest of the other competitors who does what she does. When one looks at shape, so in terms of shape, it could be how it is structured. So you would not make a mug that doesn't have an opening on top. If it doesn't have an opening on top, it should be able to open and close so that you're able to pour into the mug and be able to drink whatever it is that you're drinking. So in this particular case, I'm using an example of a door there, and that is then the shape that can be patterned. It is the shape itself. One might look at as well the configuration. And when we speak about configuration now, we speak about how things are put together. How are things assembled together? Then that will speak to the configuration, and also then ornamentation, which then speaks to what we use in terms of designs, right? And I trust that these conversations will be able to be more clarifiably explained when I start taking Q&As. But like I've said previously, if you do have a question, feel free to put it in the Q&A box. And if you do have then any question that you feel that it might not be relevant to go into the Q&A, please do feel free to raise your hand, and where we are able to recognize you, we should be able to give you an opportunity to ask the question itself. Then again, looking again at then designs. So in terms of designs, there's two ways of being able to register for that particular design. And then they all carry the different types of durations in terms of how long the registration will be able to serve and protect the organization. The first one being aesthetics, and the second one being functional. Do not worry, we're going to be able to explain what each one of them means just now. So we're going to be looking at each one of them in terms of what are design aesthetics and what are design functional registrations that we look at. But just to then use these pictures in front of us. So in terms of aesthetics, it could be how it is then put together, the looks and what it does, right? So if you look at then the first one, which is then the juice squeezer, it's then would be regarded as an aesthetic registration. And when you look at the crate at the bottom, one has to understand that then the crate would have been then in a functional registration because of what it does as well. So this is something that we need to be able to understand in terms of designs and their registrations. Truth of the matter is, I cannot just get up here and decide that I have seen a laptop that is foldable, that is a design registration, and then decide that I'm just simply going to do that and have no change on it. Now, there needs to be something that sets your design apart for you to be able to register it. So when one starts thinking of copyright, the copyright protects then the originator of the intellectual property. Now, with the designs, they credit and they protect then the specificities that are then recognized within that particular design, which is might be aesthetic or it might even be functional. So now here, just to look at one example, we can all agree that there's nothing special about the head or new about the head, but one has to understand that the moment you decide to put in the design itself and you are able to show how different it is from the other heads that you know, then you are able to register it. But the most important thing is that you should be able to show where the differences are and what is new. It has to be new. Now, that was the head. So let's look at the lady who has a hand tie wrapped around her neck. That's an arm support. Usually you would find that in the hospital, they will tell you to best support your arm if it is fractured or if it's injured, right? Now, this particular lady was able to register this orthopedic sling on the basis of the fact that it has not been tied up this way. So if you are able to prove that this is new, again, if you are able to prove that this is new in terms of design and how it is utilized, then you are able to register for it. But you must understand, the most important thing is that it must look different. There must be something new or something different from what is already existing in the market. And once you have been able to identify that which is new, and I need you to understand this, and this is the reason why I said we're going to get into your organizational context, because I need you to be able to think it from your organizational context. What is new that I'm offering, and how is it different from my competitors? How is it different from what I have already found in the market? What have I been innovative about in what I do? Do I have products? Do I have services? Are they going to be registered under designs, or should I be registering them under trademarks? So as we engage, just keep those type of questions and conversations running in your head so that you do not feel disassociated with the material that is in front of you, but you are rather able to take the information, internalize it, and be able to apply and assess it from your organizational perspective. Now, this is key. Once you have identified that which is different, making it new, then you should be able to register for it. The most important thing is being able to classify it, describe it, and show what is new and have the evidence of the newity of whatever it is that you want to be able to register. And once you've identified that, in order for you to be able to register, you will be able to file then within 6 months with the public disclosure. So once you've been able to test it, create your own models, and therefore have it within 6 months, you should be able to register it. And most importantly, there is no need to search, right? Now, let's look at what do we mean by is it new and how is it any different from that which is already existing. Now, when one is able to start looking at these 3 cups that we have, so if one was to be looking at the cup that is seated right within the circle, the cup that is written yours, I want you to imagine that this was your product. All right? I need you to be able to sit there and ask yourself, if you were a manufacturer of cups and you have this cup product and this is what it looks like, if one was to then pay close attention and you were to look at the cup that is written copy against the cup that is written existing, one is able to see that although they are not the same, they look very similar. They are substantially similar. What then the trademark or the design registration in this particular case will do is that they look at the shape and they look at the characteristics of then the cup itself. And anything that will then be found to fall within the range of the shape or the design of the cup that would have been marked as yours, similarly to the one that is written copy, then the law would not allow it to be registered because of it looks very similar. You see, but when we say yours was not the first cup to be created. There was already an existing cup. But if you look at the existing cup and the cup that is written yours, you can see that they are quite different, and therefore the existing cup will fall out of the range of your design. Remember, when you register a design, the most important thing is to be able to understand to which purpose it is registered. But as far as then looking at them, you can see that the copy closely resembles the cup written yours as opposed to the existing cup. And what is basically needed in order to be able to show that it's new, it's any addition to the product. So I remember I once had a conversation with the attorney from SNZ, and when we had this conversation and I asked, then what is regarded as new? What is new? And he said to me, if you went out and bought a cup that was not marked in any way, it was a plain white cup, and you decided to go and put a sticker be it underneath, on the side, or inside. Even if you were to just put a small mark, just a dot. So Edgar's went around for years with their red dot special saying, right? So even if I was to put a small dot on my cup, that cup, by having that dot, is something new and something different. But when it comes to designs, then it changes the conversation if the design still fits within then that which is already registered. And I'm hoping that we are able to converse a little bit more in terms of then what is required and what is what, right? So now, why? So you should be able to understand that when you register anything for a trademark or for a design, then you are not going to make sure that people do not entirely go and copy you. But what becomes very important is that it becomes a deterrent. It might not be able to protect you, but it will be able to deter your competitors from stealing your work. It might not be able to prevent them from ever wanting to copy, but it will become a serious deterrent because of anybody who's able to see that registration number. They start understanding that by copying this and being found, I will find myself in trouble. But most importantly, you have to understand that when you sell your product, and this is then the key to the why that we register for designs and trademarks. When you go to a client, so let's say, for example, and using the cup example still, let's say you produce cups, and the cups that you produce, you want to be able to go to Macro and ask Macro to add them to their shelves. And when you go to Macro, you say to Macro, this is the cups that I sell, and this is how much they're going to cost you. Now, it's very easy for Macro to can sit there and say, I will then go and look for another supplier of these cups and see if I cannot get a competitive rate in terms of the purchasing and the price of the cup themselves. However, if your cups are already design registered, it enables you to have a conversation with Macro and say, yes, Macro, you can go and get the cup anyway, but you have to understand that this particular cup of mine is design registered, which means that anybody else who will sell you the cup that is of this design might land you in hot water because of they will be infringing on my design registration. Therefore, then bringing into the client's mindset the ease and the value added by your product in understanding that I might as well procure it from this supplier who has registered this design within the right relevant authorities. You see, so over and above, it does then act as a deterrent for competitors to overestimate the bubble of protection. And usually you find that that is the case when registrations are, when designs are registered, people do not go back and ask what was really registered in terms of the design. We simply assume that it is the entirety of then the cup itself that might possibly be registered or the product that we are selling. But there are specifics that then goes into the registration themselves. And we're going to be able to look at more examples as we proceed. Over and above, we have to be able to sit in a position that it is imperative that we do this because of this particular protection or the deterrent of the registration will be enforceable for a year, which means I can spend the entire year best marketing my product without worrying about my competitors, convincing my clients to purchase my products from them. So by being able to register, then I am ensuring that my clients can only procure the product that is specifically designed and registered by my organization only from me. They cannot source it from anywhere else. Over and above, it also assists us because of we are able to can file after public disclosure, and it is cheap and it is easy and it is quick. And we're going to be able to look at all of that as we proceed then with our conversations. Now, how does one look at preparing a design application? And just to put your mind at ease, maybe somebody might be sitting there thinking, but I do not do any designs. I might have wanted to hear more about trademarks. So we're going to get to the trademarks. I just wanted to deal with then the understanding of what designs requires, so that then we are able to deal more with then the trademarks, because of that is where most of them the SMM is. We find ourselves in the gap where we really want to be able to protect our slogans, our logos, and even our company names. But when preparing for a design application, it is very imperative that one understands first the article name to which then the design is being registered to. And there's a range of article names. So when you do the registration with the SASDC, and we do it with SNZ, we utilize a software system called TM Direct, which then is able to identify and assist even people who do not have the experience in registering for designs and trademarks to be able to find easy the article names, to be able to easily understand whether they're going to be registering for aesthetics or for functionality of their designs. The class is also easily explainable, because of with every single registration, there needs to be a class to which the particular item or the product is classified under. And then it will be the applicant's name, the simple pictures, drawings, if possible, of the particular design that you would like to register. Now, what is optional are the explanatory statements and the dotted lines. And a very interesting fact about the dotted lines is that it's not all the countries in the world that then recognizes the registration of designs with dotted lines. China is one of the countries in the world that do not identify them nor recognizes those particular registrations. So now, earlier on when we looked at the design types, I said we will get to a part where we explain them in detail. So when we speak about aesthetic design, we're speaking about the protection of the features of shapes that are dedicated by the eye appeal. So here we're speaking about, is it attractive? So the design is what is then attractive to the buyer. It is not that the product functions differently from how the other one works. Take a very simple example, toothbrushes, right? So toothbrushes are toothbrushes and are toothbrushes. They do the same thing, they brush the teeth. But you are able then to say, because of this particular design is appealing to my clients, that is the design that I'm going to trademark. As opposed then to looking at the functionality of the particular design. So there are times when we speak of functionality, we are speaking of the fact that the design speaks directly to how the product is supposed to function. The design protects the features of shape that are dictated by the function of the particular item that is being registered. So, which means that the design has a direct influence to how it functions. And that is what you are now protecting. And when you register it, you will register it under functionalities. And then we spoke of broken lines, right? Only portions that are made separately may be disclaimed by showing them in the dotted lines. And these are the dotted lines that I'm speaking to. And in most cases, I prefer that, during the webinars, so that then one is not bombarded with information that then comes through. It becomes very imperative that I'm able to then allow you to know that you are able to engage with us as the SASDC, and particularly me within the SASDC, because I'm responsible for the registrations of patents, trademarks, and designs. Now, when one considers that, there is a more rather in-depth conversation that needs to take place in terms of understanding what each of these particular mean in terms of the registrations and what implications they will have on your own registrations. And there are some similarities in terms of the different countries that then you will get protection of. And there's over 177 countries in the world that does recognizes patents and design registrations. And with that said, then it becomes very imperative that you are able to have the conversation first in order to be able to understand to what is it that you would like to really be able to register within your organization. Right, and when we speak of explanatory statements, the explanatory statements assist a judge to understand the article, which means that here we are speaking to the references of the symbols that may be used or associated in reference to either the drawings, the pictures, or any other information that one will be in a position of submitting when they looked at the trademarks and the design registrations themselves. So now we have a wide range of different types of products that could easily be registered. And when one then looks at these particular types of then the articles that are registered in, they are registered under different articles, and each one of them is registered for a different purpose. It becomes very imperative that then when you see it and you look at your organizational context, you ask yourself if you do have the products that you would like to register as for their designs, be it for their aesthetics, because of you know that your clients like them and they like how they look. So which means that you are most likely that your competitors might want to steal them, or even on the basis of the functionality to which that particular design is meant to be able to achieve through the product. Now, in that particular case, you equally need to be able to assess that and ask yourself, what within my organizational context become rather more relevant for me to be able to register, and what should I be considering when registering for my designs? Now, there's a simpler example that we would like to use, or rather that we have chosen to use in this particular webinar. And one might be familiar with then the Woolworths baby Ubuntu Baba baby carrier. So one has to understand that the original idea and the reason why Woolworths ended up in a court case in arguing the particular design and the functionality of the Ubuntu Baba baby carrier was because of, like a lot of SMMEs, the originator and the designer of then the Ubuntu Baba baby carrier did not take the liberty to register this particular item in terms of the design registrations. So, of course, there are a lot of baby carriers. I mean, there's plenty of them. And one then has to be able to understand that it is very important that when you go and you start presenting your idea to different or potential buyers, you equally recognize that the buyers have the ability to can reproduce it. Similarly, as your competitors, when they see it, they might sit there and desire to have the similar product. Now, what you want to do is to deter them from copying the similar idea that you have put together. Now, what happened is that a seller approached then the organization, showing them what is it that they have put together and what is it that they have as a special product and how different it is. However, if then this particular carrier was registered under the design's registration, it would have been impossible for the client to say, no, we see your product, but we're not going to buy it from you. We are going to reproduce it ourselves. We are not going to buy it from you. We are going to reproduce it ourselves. Now, it would have been a perfect deterrent if then the supplier or the originator of the carrier would have been able to be in a position to say, you cannot, because of this particular design is registered. So anybody who copies this design will be infringing on my design registration. But in the absence of such, then it becomes a serious problem because of you are unable to prove that this particular design was originated by you. But most importantly, there is nothing that is preventing or deterring anybody from copying your idea. And you should be able to sit in a position where you see the value of the design and the trademark registration for what it really is. It is there to be a deterrent from preventing and just discouraging people or competitors or even buyers from simply copying your product, right? So timelines, let's speak about timelines and the extent to which you could be protected or have the particular deterrent effective form. Now, there's no substantive examinations, but one has to understand that the acceptance of the filing might be within the duration of 9 months. The publication goes on within the 3 months of acceptance, and the certificate will be issued within the 14 months after the filing has taken place. Now, with the designs, we have said there that the design would then provide you with then the protection or the deterrent within a space of 10 to 15 years based on what is it that you are registering your design for. But then you have to honestly understand that then there would be a requirement for annual renewal after every 3 years. oh, sorry, from the third year that the design has been accepted or being approved and the certificate has been issued on that particular design. So from the third year going forward, then you will need to be able to renew that. Now, that was about designs. So when we spoke earlier on, I said we're going to cover trademarks and designs registrations. Those were designs registrations. And for those who are interested in applying for any design registrations, I would recommend that you actually have an extensive conversation in understanding what is it that you are going to register. I would urge you to consult and source out the right and relevant information in order to understand the background context of what it is that you are going to register. Because of it is always very important to understand that even when you disclose such conversations, you also look at non-disclosure agreements. It is very imperative that you understand that your organization does not operate in silos. Your organization operates in its entirety. Non-disclosure agreements from the people whom you're sourcing out advice and guidance from, so that they do not then become the people who steal your particular design and end up registering it before you do. So it is always very imperative that you understand it. But that is around designs. And I also want to emphasize the fact that when one really wants to think design registrations, start thinking of all the innovative efforts that you have put into putting together the product that you have put together. And ask yourself, is it really worth me going through the trouble of putting all of this amazing product together only to be easily copied by a competitor who might end up making money on it? Because you should remember that every time they sell something similar to your design, they might be making money off you by then taking clients away from you. The idea might be that the client might be thinking that they're buying the product from you, only to find that it is not you who sells the product. It is a competitor who just saw that this product is selling and therefore decide to copy it. Which means that is money leaving your organization. That is money leaving your business. That is you losing clients to the competitor selling your product. So that is why it's so important. But then let's talk to something rather more interesting and easily relatable to. It is very easy for us to relate to trademarks because of trademarks are what we get to see on a daily basis. Trademark speaks to what we have as any organization. We have the names of our companies. We also have the slogans that we come with. We also have the logos that we design in order to be able to build our brands, and equally so, be able to build an image around the products and the services that we sell. Now, we know that Black Cat is Black Cat and Black Cat has always been produced as such. But then one has to be able to understand that Black Cat has been able to trademark the name, the color scheme, and also the logo that they use. Because of it was very imperative for them. So it doesn't matter over the years as Black Cat then continues to modify, improve on the quality of their packaging. The packaging cannot be duplicated or copied by a competitor. In doing so, you will be infringing on their trademarks rights. And that is how we need to be able to start thinking of our organizations. And if one is probably sitting there and thinking to themselves, but why I'm an SMME, probably haven't started trading, or even though you are trading small. You should remember that your brand is built around those particular slogans. Your brand is built around the name of your organization, and your brand is built around the logo and the packaging which you put together to be able to have your clients easily familiar and recognize your products as such. I mean, one has to think of Coca-Cola, one has to think of Nando's, and one has to think of the likes of the BMW. All of these are trademarks in terms of their slogans. I mean, in terms of their apologies, in terms of equally so the names and also the slogans that they use, the logos that they use as well. And the reason it's so imperative that they sit in a position where these particular sections or items of their intellectual property are protected, it's because of it might be easy for anybody sitting in any country to decide to start saying, oh no, I'm going to produce poor quality cars, and then I'm going to remove then the different types of branding that might be there, and then I'm just going to slap a BMW or a Mercedes-Benz. Now, people are more familiar with the Mercedes-Benz and the BMWs, and they might then buy that brand hoping that it is indeed of the quality of the Mercedes-Benz or the BMW, only to find that it's not, because of it wasn't produced by them. So to deter anybody from using their names, their slogans, or their logos, they ensure that then you are not seated in a position where you sell the product that doesn't belong to them under the brand that they have built. And one have to really consider that we spend a lot of money in designing brands. And as an SMME, you might start asking yourself, but I do not really have a brand. You do. You really have a brand. The moment you had a registered company with that name might be taken by somebody else if it is not properly registered. Or there might be a similarity. I've worked with a number of organizations, and recently I found myself sitting there and looking at two financial companies that does the similar things, but were almost similarly named as well. And I thought to myself, but this was going to be very confusing. I saw a company called PZ Institute, and I also saw a company called PZ Investments. Now, if one was to look at just then putting it in terms of an acronym or an abbreviation, you end up with PZI for both of them because of it's an institute and investment. So in order to be able to make sure that whatever any of these two organizations does going forward ensures the protection of their brand, needs to ensure that it does specify that this brand is around the PZ that they are specifically speaking to. So we understand that we spend a lot of money in developing brands, and that is the reason why it is very imperative that we are able to deter people from stealing or copying those particular brands or those particular things that has become a niche for us to be able to be easily recognizable by our clients when buying our particular products. So when you look at trademarks, there's a lot of things that you can really trademark in terms of how one looks at an organizational brand setup. Remember that it is all about being able to protect the image of your organization, but most importantly, not losing clients because of a competitor who is stealing the products, the designs, or even so, the logos and the shapes that you have put in place, right? So when we look at trademarks, we see that in trademarks, we can register words, we can register logos, we can register shape, we can register slogan, and we can also register the color schemes that we utilize as part of our branding. We can even register the color schemes that we utilize for our branding. As we can see with Coca-Cola here, it doesn't matter where you go, the Coca-Cola branding, you're always going to know it because of Coca-Cola has ensured to register their color schemes, that nobody else might come and produce another soft drink and use this similar color schemes, which could be very confusing to a lot of Coca-Cola's clients, right? So when we look at then particularly trademarks, or rather, let me just try and go back a little bit and maybe explain what do we mean by being able to register a word. So if one is able to then consider that the name of an organization is words, I haven't seen an organization named in alphabet, in science, in signage. So the words themselves could easily be trademarked, right? So for example, the name Nike would have been trademarked as Nike. And when you look at then the logos, Nike has trademarked that tick. That tick that has been in existence since you were in primary school, whether they were marking you right or wrong, that tick has been trademarked as a logo of Nike. So that is how you know that this is a Nike, even though you don't see the word Nike, but by the virtue of just simply seeing that tick, you automatically do relate with it and identify it as such. The shape as well, the slogan, just do it. So you see, if the Nike was to just put a line across, that would have been the shape that they chose, but then the shape that they chose was that tick. But as for then the slogan itself, the slogan behind then became just do it. I mean, similarly with KFC selling chicken, they've decided to differentiate themselves from all the other brands of chickens out there, such as your Nando's and your Chicken Licken, by saying finger licking goods or finger licking good. And then I remember it was after the COVID-19, I started seeing different types of slogan come out of KFC. And my take was that perhaps maybe it was because of KFC didn't want people licking their fingers at this point in time. With the COVID going on, that might not be a very good suggestion to go about telling people to lick their fingers. You can't. I mean, you sanitize with everywhere you go. So then that might have requested or required them to revise that particular slogan to suit how they best sell their product. But if anybody was to come to you at any given time and tell you about licking fingers that are good, the automatic response in the mind becomes, oh, KFC. Because of that's how we've been able to perceive it. Right. And as for the color schemes, I've touched on them in terms of as well Coca-Cola color schemes and how they've been able to utilize them. Now, when we look at trademarks, in trademarks, we cannot trademark something that is descriptive, like Wonder Polish, Bouquet Wine, Tech Services. You can't because of this is descriptive. You can't say clothing and then trademark clothing. It's descriptive. I mean, we have to use the word clothing, and in so then we cannot be owing you anything, even when we're supposed to promote our products. So you cannot trademark tech services. The SASDC has an e-biz center which specializes in assisting suppliers with their tax compliance and financial compliance management systems. So we do deal with tax services, and if there any way to trademark that, you will put a lot of people in a very, very difficult position right then. But then there's also some generic words which you cannot really be able to trademark. Liquorize, all sorts, wind, suffer, nylon, escalator. These are words that are very generic and you are not able to then trademark them. So let's look at what are you able to then trademark, or how to even perform a trademark search. So when we speak of trademarks and what you are able to trademark, this needs to be clean. You can trademark the word, a shape, a slogan, a logo, or a color scheme. So which means that within organizational context, there's quite a number of things which you could be already utilizing in order to ensure that your clients know who you are, and equally be able to deter any competitors from stealing the work that you do by convincing or confusing your clients with similarities in the products that they sell. Perhaps maybe when we then get more and more into then the presentation itself, looking at different examples, we will be able to get better understanding of that. So how we perform it within the SASDC is that within the system that we utilize, we are able to perform different searches. And then the search, if it was a word mark that we wanted to register, then it would be a matter of going into the word mark search and then search if that particular word mark hasn't been registered. So when we looked at the design registration at the top earlier on, it had a page, or rather a writing with a block on the side that was written genocide. Now, genocide is now a word that is trademarked because of genocide was brought up by an organization that said this word was not in existence before. They knew that gems existed, and they also understand that the homicides spoke to killing. So what they decided was to put together two words and call it one word and make it genocide, which means gems killing, and the side taken from homicide, the gem taken from the gems as in viruses and bacteria and things that have the ability to make you sick. So when one looks at then words that can be registered, then one starts being able to see where those particular words may be coming from, and if you are the originator of the words, right? So when we search for the word search, we then look at the similarities Does it sound similar? Does it look similar? Conceptually, is it similar? Does it exist in other languages where it might mean something else? Because this could be confusingly similar. Um, and that happens quite often, as a matter of fact. And as for why, we do this so that we ensure you benefit from your reputation. Again, remember that as organizations, we sell the products that we sell, and we sell them the way that we sell them because of we build an image and a brand around them. So our clients buy those products from us because of how we best present them. When somebody else then just get onto that bandwagon of stealing that which you have previously put to your client, it might be confusing for your clients to differentiate that this is your product and this is the competitor's product. But when trademarked, you ensure that you do not lose any benefits that goes hand in hand with the registration of the particular reputation that you have already built for your organization. But this also increases the value with the use and can be renewed in perpetuity and protects domain with registering all of them. So by looking at the entirety of the registration itself, you are then able to best protect them. So when you look at fallacies, cannot value and add to balance sheet. Now, what it doesn't do, what it doesn't do is that it does not add value to the balance sheet. So by trademarking a product, a slogan, a logo, or a name, it is not going to add value to a balance sheet. However, it is going to make sure that you do not have competitors who steal your clients claiming that your product, their products are your products by simply copying them, right? And this is completely different to company names as well. So when you prepare for a trademark application, it is very, very important that we understand the process that goes then in us being able to register. But this is far more simpler than when trying to register a design. You see, with the trademark is a lot more simpler because of you only need to have either that mark, that logo, that name, or even the color schemes that you are liking to be able to register. And then you will only need the applicant's name, and we only need then the class to which that it falls into. And the idea that it needed to be this simplified is because of a lot of organizations in South Africa do not protect their intellectual property or even their product brands. And it's because of we have this idea and concept and a notion that it is very expensive and it is very complicated. But in all honesty, it is not. It becomes complicated based then on the process that you will follow in order to be able to register. But how the South African Supplier Diversity Council, in partnership with SNZ attorneys, do it is that all happens online, and each one of this particular information, we are able to help you with putting them together and in being able to also best describe them. So there are various types of then what one might call classifications in terms of how one will be able to register for a trademark, right? And in so saying, then we also are able to understand that you might not have the knowledge to know how to classify your product, your logo, or whatever it is that you want to be able to trademark. And where we come in and where our services then becomes rather more simplified is the part where we are able to assist you in identifying the classifications and even the type in which the title is going to be put in by being able to utilize the system that we utilize. And because of we do everything online, then it saves you the time in traveling costs. It saves you the time in even needing to deal with various copies. We do everything on the system, and the system is made up in such a way that it streamlines the entire process for your registration simplicity. So for different types of classifications, then there's different types of of items, there's different types of classes to which those items will be registered under. And these are some of the examples of those particular classifications in existence. So all of this will be part of then clothing branding or clothing and branding. So you might have clothing in terms of the footwear and the headgears. You will have clothing in terms of sunglasses, protective clothing, jewelry, watches, bags, umbrella, and walking sticks. And all of this will then be able to be registered under different types of then the classes that they fall under. And as for the timelines of examinations and reports, it will take about 9 to 12 months of filing. And I've also then touched on then the other durations earlier on. And it's important that you understand which timeline reflects or rather speaks to which particular item. So the responses to examinations reports are within 3 months, and acceptance is between 15 to 20 months of filing, within the publication within the 6 months of acceptance. Now, truth of the matter is, once you get then the registration, when you have the confirmation that you have done the registration, you are able to start utilizing that particular trademark while you are still waiting for the completion of then the publication to be able to be done. But you also have to understand that you also have an opposition period of 3 months from publication. So once it is publicized, then there is that 3 months grace period where individuals are able to come in and dispute the registration itself and maybe say, but no, this falls well within my registration of a trademark. Then the judge might have made mistake in granting this registration because of it infringes on mine. And with them, then for the certification, the certificate within 6 to 8 months of acceptance will be issued. Now, the trademarks process, which is what I believe that most of us might really be interested in, is that when we do the completion online, if there are no objections, then we understand that the process should be completed within 12 to 20 months. 15 to 20 months. The publication will then happen in 6 months, 3 months for any opposition or to be taking place where there's anybody who opposes the claim to your trademark. And then there's then the part on issuance of registration and certification that will follow in then the 4 months then. However, if there are any examinations or objections or disputes, then working with SNZ attorneys, we request them to send emails on your behalf, and this is done, and an opinion regarding on how to respond is done and is handled within the 9 to 12 months of then the first acceptance. If not accepted, that is then it comes back for objections. But also, then there's also then after the 3 months where the SNZ responds to the office actions, if there are any, and this speaks to where there's objections in terms of your application not being approved. The nice thing is that all of this takes place online. All of this is systematic and it's web-based. So it then removes a lot of requirements from you and allows you to be able to focus on the most important things in your business, while then the professionals who are responsible for the registrations are able to provide you with the assistance. And truth of the matter is, it goes without saying that it is going to be very costly if you had to do it outside of the SASDC. The SASDC has partnered up with SNZ because of they specialize in these particular registrations. But we have a large number of corporates and SMMEs that we work with. And by being able to then market this particular product to you, we are able to then negotiate a very reasonable amount for you to be able to do this. Because of we are a non-profit organization, we do not intend on making money out of you registering. Our sole mandate is to ensure the growth of diverse suppliers. Right. So I've touched on it earlier on that it is very important that we understand that different trademarks are applicable and are recognized in different countries. And like I have said earlier on, there is a list of where different trademarks are able to be identified. And when you register within the South African context, then your trademarks and your design registration will be identified and recognized in these countries. And I know that you might be sitting there probably thinking to yourself, but I'm not even in international business. I always say we do not work with small businesses. We work with businesses that are still small, that are gearing up for growth. So when you work with us, the intent is that the aim is to grow and to be able to operate in international markets. And when you operate in international markets, it is always very important that you understand that your product can be copied in the country which you're selling it. So in order for you to be able to put a deterrent to them copying it and passing your product as their own, then you need to be able to register that particular product or that particular service under the trademarks registrations. So let's take, for example, the simplest reasons why we see that it works as a deterrent to register for trademarks. It is very important that you understand this. That for years, everyone thought lifesavers patent the hole in the center of the suite. So I don't know if you're familiar with the suite, the lifesavers. So the lifesavers were the first suites that had a hole in them. And when lifesavers came out, they came out and they had this patent and trademark registration on their wrapper and the product, which is then the suite itself, right? And a lot of people then went around and did not understand what was it that Lifesaver had actually patented. And they went for years asking themselves what was really registered. And everybody stayed away from manufacturing any suites with holes in them. But the truth of the matter is that's not what was actually registered. What was registered was the wrapper or how it opened. They actually registered the wrapper and how it opened up. Now, if somebody might have thought that, you know what, Lifesaver was able to go on for over 100 years, making sure that everybody stayed away from their product or their product looks and what they wear, then they really won because for many years, nobody has ever again produced any suite with holes in them. And even so, they even stayed away from the wrapper itself. They stayed away from the wrapper itself and remained to be the only ones. And all because of no organization wanted to go back and ask what was really registered as a patent by Lifesaver. It wasn't the whole, it was the wrapper. So it is really working as a deterrent. And you need to be able to identify that your product is then the thing that you have decided to put in the market to solve the issue or the gap that you have seen from the buyers, right? So this is the most important thing. They serve for protection, deterrence, and ensuring that they assist you in your marketing, the brand, and the image of your organization is always protected. So you could expect that you would have some leg to stand on in terms of giving people a stick or hiding when they start copying your products or your services that are trademarked and registered under the designs and trademark registrations, so that then you do not need to be able to deal with all of these issues, supposedly where they have to copy or steal your design or your logo or the ways that you use to best sell your products. And I was hoping that this becomes more rather simplified in terms of how do we perceive trademarks and designs registration, so that we take this first conversation and we internalize it and we self-reflect on it, and we are able to go into our organizations and ask ourselves, am I really in a position, based on the services and products that I came up with, to be looking into registering them under trademarks or designs based on the relevance of them in order to be able to best market them, best protect my brand, and ensure that any copycat who might be trying to steal this particular item and pass it as their own will not be able to do so. And with that said, this is the end of the presentation for the trademarks and design registration. Thank you very, very much. We will hope to see you in our next and upcoming webinar. If you need any more information about our organization, we are situated in building number 9, the first floor at St. David's Office Park. That is in St. David's Place in Parktown in Johannesburg. We also have offices in Cape Town, and we also have operations in Durban as well. If you need any more information, you can call our number on 011-100-1025 or email us at info@sasdc.org.za. Or even better, just use my personal email address. I'm up to date with email communications. And with that, thank you very, very much. May the Lord bless you all. Thank you for attending. We are done.